Let's see if we can fix that.
We are now live.
Okay. So good afternoon, everyone. My name is Shamon King, and I am one of your two moderators for today's event, part 2 of our 3-part symposium. The other moderator is Mr. Nathaniel Amor, chairman of the G2K Foreign Affairs Committee, and I'll now invite him to give the welcome.
We are now live.
Okay. So good afternoon, everyone. My name
Greetings, everyone. It's truly a pleasant day to be here. It is definitely a joy to see thought become action. It is definitely a joy to see weeks of planning turn into a finished product. We are here before you today to present a data protection symposium, but today in particular, we'll be focusing on the legal aspect, data protection and cybersecurity. At this point in time, we recap what was discussed on our previous meeting. During our previous meeting, we had a general discussion on the cybersecurity and data protection mechanisms that we can employ in our day-to-day lives. There's a lot of focus on what companies can do to protect their information. There's focus on what individuals can do to protect their information. And there was just a general focus on how unaware a lot of us are as it relates to cybersecurity and data protection. So now that the foundation has been set, we now move into discussing the legal aspect, the legal framework that we have to consider when we are looking at data protection and cybersecurity. We have a panel of exceptional guests. We have persons who have years, combined decades of experience within the legal profession. And we hope to dissect as much information as possible and present it to you, Jamaicans, persons across the globe at home who are listening, so that we can all be fed with the knowledge that we need. We're currently moving into the technological era. Most of what we do is within the cyberspace. And as I had said in the last meeting, we do not want to get left behind. We do not want to be ninth in preparing ourselves for the technological era. The same way we dust them on the tracks, we're hoping that Jamaicans can dust them in the cyberspace. So I welcome you all. I hope you all sit back, relax. If you're commuting to go home right now, just take your time on the road. I hope you're not looking on the screen and you're listening, because there's information here for everyone. And I'm going to hand over to our lovely, capable, competent co-host who has been very instrumental in putting this event together. Back to you, Shamon King.
Okay, thank you, Mr. Amor, for that lovely welcome. At this time, I'd like to invite our committee member, Ms. Yetunde Oke, to introduce our first speaker, Mr. Chris Hydak.
Good afternoon, everyone. This evening, we have with us Mr. Chris Hydak, who is a senior corporate counsel in Microsoft's Privacy and Regulatory Affairs Division, where he advises on global privacy laws and regulations. Before Microsoft, he was in-house privacy counsel at USSA, a financial services company, serving the US military and their families around the world. Prior to USSA, Chris spent approximately 6 years in the privacy practice groups at Hunton and Williams LLP and Ropes and Gray LLP in New York. Chris received his JD from Vanderbilt University Law School. Everyone, please join me in welcoming Mr. Chris Hydak.
Thank you, Tita. That was great. So just to recap, I'm a senior corporate counsel at Microsoft, and I'm in the privacy and regulatory affairs group, which means that I focus on data protection and privacy on a daily basis, how Microsoft can collect it, who Microsoft can share personal data with, and you know how Microsoft processes it, where it can process it, where it stores it, all those kinds of things related to data protection. And I've been at Microsoft about 3 years now, but I've been in the data protection world for about 10. And so I'm going to focus this. We've got a lot of great folks that are going to be talking today, but I'm going to focus on the US legal regime. And I'll talk a little bit about Microsoft and privacy in the United States as well, outside of the legal regime. But the legal regime in the US is historically a patchwork of sector and state specific laws. And the US has had privacy laws for a long time. It just hasn't had that one big heavyweight privacy law like the GDPR. So we've had HIPAA for over 20 years, the Health Insurance Portability and Accountability Act. HIPAA, we think about it in terms of generally medical information normally, and it is medical information, it's protected health information, but it only applies to covered entities and their business associates. And a covered entity, there's some nuance, but it's generally healthcare providers and health insurance companies. And so on the medical side, we have HIPAA. And then for over 20 years, we've had Gramm-Leach-Bliley Act on the financial side. And the Gramm-Leach-Bliley Act, similarly, we often think about it casually as applying to financial privacy information. But what it really does is it applies to financial institutions and the personal data that those financial institutions collect and process. And I'll try to go through these quickly, but we have this huge patchwork of sector specific laws. And we have the Fair Credit Reporting Act, which applies to consumer reporting agencies and furnishers of information. Now, these tend to be the big ones, companies you may think of are like TransUnion and Equifax and Experian. And this applies to building credit profiles of people, to issue mortgages and to issue loans and another type of credit related products. And then we have some marketing privacy laws. So we have the Telephone Consumer Protection Act, and some folks may be familiar with that because it is a heavily litigated telemarketing law that applies to marketing, and then also applies to calls made with an auto dialer. And that's been around for 20 years, more than 20 years as well. And it carries heavy statutory penalties. So it's had, there's a lot of litigation about it. And we have CAN-SPAM, which is similar to the Telephone Consumer Protection Act, but CAN-SPAM applies to email marketing. And so we've had these huge and bevy of sector-specific and state-specific laws. And then California, 20 years ago, instituted a data breach notification law. And then that proliferated across all 50 states relatively quickly. There's a few states that held out for the last few years, but so we've had, the United States has had mandatory data breach notification for over 20 years. And that the data breach notification in the United States traditionally was to notify the impacted data subjects, depending on the state of residence, of course, but there was also some regulator notification obligations as well. So this patchwork of privacy laws that we've had in the United States is still in existence. And there's some of the laws are still heavily regulated and governed both by the plaintiff's attorneys and by regulators. But what we're starting to see now is kind of this shift towards the more global nature of privacy laws, which is kind of comprehensive privacy laws that apply to every organization. And that shift is happening in the United States at the state level. We still don't have a federal, so at the national level, we still do not have a comprehensive privacy law at the national level, though that may change at some point. Every successive president in the U.S. States that they are interested in that, but of course the details we get bogged down in the details. We haven't issued one, but on the state level we have. So California led the way again and enacted the California Consumer Privacy Act, and other states are following. So Colorado and Virginia have now also instituted comprehensive privacy legislation, similar to California's Consumer Privacy Act, but with some discrete differences. And I'll get into California's law in a second because I think it's kind of the trend. But it's worth noting that this trend towards these state level comprehensive privacy laws is making privacy regulation in the US, if anything, more complicated. So we still have these sector specific privacy laws that I just talked about a second ago and gave a very high overview of. And now we're starting to get these state privacy laws. And we already have state data breach notification laws. So now when you're advising a company in the United States, or your company is in Jamaica or in Europe or wherever it is, and it's processing personal data of US individuals, it can get really complex and really opaque really quickly. And so there's some interest that a federal privacy law could simplify this and give people one law to look at, or at least one main law to look at. But just to deep dive a little bit into the California Consumer Privacy Act, or the CCPA, as its acronym is, it's recent, and it started out as a ballot measure. And what I mean by a ballot measure is California has this. This is by state, but California has this democratic process where if you collect enough signatures and submit them to the California government, you can get a statewide vote on something. And that's exactly what happened. The backers of the California Consumer Privacy Act collected hundreds of thousands or millions of signatures in California, took them to the state. There was going to be a statewide vote on it. At the last minute, the California legislature got the backers to remove it from the ballot. And they passed substantively similar legislation, which is what we have now as the California Consumer Privacy Act, the CCPA. It's similar to the GDPR in a lot of regards. It has broad applicability, so it applies to organizations processing the personal data of Californians. There are some exceptions if you're a small organization. If you're entirely brick and mortar and you're small, there are some exceptions where it doesn't apply to you. But generally, if you're a moderately sized business, the CCPA applies to you. It is similar to the GDPR in that it has a broad definition of personal data. Historically, a lot of US laws have had more narrow definitions of personal data, medical or financial in certain and peculiar scenarios. And this is now all data that's related to or linkable to an identifiable individual, similar to more global standards. It has data subject rights that other folks I think will talk about, but the right to access your data, the right to correct your data, the right to delete your data. Companies in the US that weren't previously subject to the GDPR or other international laws have had to implement mechanisms to allow consumers to access their data, correct their data, delete their data in accordance with the CCPA. One of the interesting things that the CCPA did that's not in the GDPR or other international laws is it added this concept of selling personal data. And what I mean by selling personal data, it's very broadly defined in the CCPA, and it's disclosing personal data to another organization or to another entity for monetary or other consideration. And there are some exceptions. Some of the normal exceptions are if it's a service provider or a processor in Europe. If it's a service provider and that's only processing data on your behalf, that's not a sale. If the consumer directs you to transfer the data to a third party, that's not a sale. But otherwise, everything else seemingly falls in this definition of sale. And we've seen companies, you have to do certain things with your selling personal data. We've seen companies, you may have gone to a website where there was a California option. Some companies have limited it to California. Some companies have made it more broadly the United States or everybody. You may have a link that says, do not sell my personal data. And consumers can click on that link. And what happens when you click on that link and ask for your data not to be sold is the company should cease disclosing your data in the manner that it considered a sale under the CCPA. The big kind of question mark, of course, has been, well, what about all the kind of advertising scenarios in the kind of the modern internet ecosystem? Are those sales? And companies have taken different perspectives on that. A lot of companies have adjusted their contractual relationships to make other third parties in that ecosystem service providers to avoid the sale requirement. Some companies have simply instituted the link and the opt-out mechanism. And the CCPA is relatively new. It started within the last year and a half or so. And we're starting to see some Attorney General enforcement now. So, the Attorney General ramped up, and now we're starting to see some enforcement. And the enforcement so far, the Attorney General the California Attorney General released an update, and that enforcement has generally taken so far it's been, hey, you need to get in compliance with the CCPA. Most companies are voluntarily complying, but we'll likely see some more serious enforcement going forward. The California Attorney General seems interested in enforcing. Just to add a little bit of complexity, of course, this is again California kind of leading the way. There's now the California Consumer Privacy Rights Act, which modifies the CCPA, and this is known as the CPRA. It is coming into effect in January 1st of 2023. So we're still over a year away from it coming into effect, but it creates a California Data Protection Authority and adds some new obligations. But of course, that's not coming into effect for about another year and a half. We will start to see more states do this, and maybe at some point we'll have a federal law in the United States. And just to wrap on a couple of things about kind of general privacy in the US, it's flourishing. When I started in privacy about a decade ago, it was a relatively small niche for lawyers. It is becoming quickly, every law firm in the United States, it seems, has a privacy group now. There's a bevy of consultants and advisors on privacy, and it's just flourishing over here. And some of that may be because of the complexity, which is not necessarily a good thing, but there's all sorts of traditional and non-traditional routes into privacy now. And with that, I will pass it on to the next presenter.
Okay, thank you, Mr. Hadak. Thank you for giving us a detailed background on the complex framework which exists in the US. It was interesting to learn about the sector-specific and state privacy laws, as well as the similarity of the GDPR to the law which exists in California. At this time, we'd like to invite Ms. Cheyenne Hilton to give the introduction for Ms. Justine Collins. Both her and Ms. Joanna Marzuko will be focusing on the Jamaican perspective. But before Ms. Hilton comes on, I would also like to encourage everyone to utilize the comment section. If you have any questions, we will also have a question and answer session at the end of every presentation, at the end of all the presentations, sorry. So please utilize the comment section. And you may also mention us on Twitter or on Instagram. Okay, unfortunately, it appears that Ms. Hilton is having some difficulties. So I would go ahead and introduce Ms. Collins. So Ms. Collins was called to the bar in Jamaica in 2016 after having completed her studies at the Norman Manley Law School. She received a Bachelor of Laws degree with honors from the University of the West Indies Cave Hill campus in Barbados. Justine is also the holder of a Master of Laws in Commercial and Corporate Law with distinction from Queen Mary, University of London. As a research assistant at Queen Mary, she conducted research into applications of blockchain technology beyond Bitcoin and other cryptocurrencies. She has an avid interest in technology law with a research focus on blockchain applications, computer law, financial technology, and e-commerce. Justine also has a certificate in fintech law and policy from Duke University and a certificate in fintech from the Said Business School at the University of Oxford. Justine is a member of the Caribbean Blockchain Alliance, the Jamaican chapter of the Internet Society, the Computer Society of Jamaica, and the Commonwealth Lawyers Association. Justine serves as a director of Access Financial Services Limited. Justine has published articles from the International Journal of Law and Information Technology, the Social Science Research Network, and the Jambar Journal. She has presented at the Commonwealth Lawyers Association in Livingstone, Zambia, the Organization of Commonwealth Caribbean Organizations Conference in Florida, USA, the 14th Annual Regional Investments and Capital Markets Conference of Jamaica Stock Exchange, Annual Conference of the Jamaica Bar Association, the second Annual Conference of the Barbados Bar Association, the fourth Annual Mono Law Symposium at the University of the West Indies, the Jamaica Stock Exchange e-Campus and EU GDPR Institute Data Protection Workshop, and seminars of the General Legal Council of Jamaica. In addition, Justine has presented submissions on the Data Protection Bill to the Joint Select Committee of Parliament here in Jamaica. Ladies and gentlemen, please welcome Ms. Justine Collins.
Hi, good afternoon, everybody. Thank you so much for that excellent presentation, Chris. I really enjoyed it and I learned quite a bit. I wanted to just speak generally about the Jamaican legislation and how we came to this point. My colleague, Joanna Marzuka, will give further clarification regarding the commercial considerations. I just have a couple slides that I want to share just to guide the presentation. See if I can get it up on the screen. Sorry, are you seeing the screen? Ms. King?
No, I'm not seeing the screen at this time. I'm not sure.
Okay. How about now? Are you seeing it?
No, it's not visible.
All right, if anything, I'll just...
No, I'm seeing it now.
Okay, you're seeing it again. All right, great. So just to run through really quickly, I know that we are pressed for time. So I'll be looking at the Jamaican Data Protection Act 2020. It was passed last year by our parliament, and it replicates a lot of the principles that we were hearing Chris speak about, and I'm sure that my other colleagues from the UK will go into further detail about. So just to look generally at the context of data protection and what data protection looks like. Data protection is a fairly European concept. So it was something that was passed historically in the federal German state of Hesse in 1970. And this, of course, was back when computing was largely different from it is now. But when you look at the content of the laws from that time up to today's date, generally speaking, it hasn't changed that much. The first national provision on data protection was the Swedish Personal Data Act of 1973, and that evolved into the 1984 Data Protection Act in the UK. This created a supervisory body for businesses, the data protection registrar, similar to the data protection officer that we know about and the information commissioner's office that we know about right now. It created an offense for data users who did not register with that registrar, and that act limited it only to digital data. Now, the Data Protection Directive in 1995 was a step forward. But in the 90s, of course, we know that there was the emergence of the World Wide Web. And the problem in Europe was we don't have a harmonized European regime for the regulation of data protection. So the 1995 Data Protection Directive represented this step of harmonizing in the European Union data protection laws, as well as recognizing that need for greater enforcement powers. The 1995 directive, of course, yielded to our Data Protection Act of 1998 in the UK, which is very important because most of the context of our law in Jamaica is modeled on that 1998 Act. There are some revisions that have been made since the passage of the GDPR, but substantially speaking, our law reflects that quite a bit. So some of the things that the 1998 Act provided for was the provision for the Information Commissioner. It also covered non-digital and digital data. We saw definitions of personal data, sensitive personal data, which has other considerations in terms of how you handle that data. And of course, we've heard that keyword GDPR, and we're not sure exactly what it means. I'll yield to our UK colleagues when they have their time, but the GDPR came into force in May 2018, and there were lots of penalties and lots of repercussions coming from that in terms of compliance. In 2017, we had a draft bill that went to Parliament. And as I said before, it's based primarily on the 1998 Act from the UK, and eventually with some revisions from the GDPR, which would have come into force after we drafted our bill, we have our Data Protection Act 2020. And this really comes from an economic partnership agreement with CARIFORUM and the European Union, which required the Caribbean states to enact certain data protection laws in their domestic legislation. So we see around the region, we see a lot of countries now enacting their data protection laws. Some have done it before us. We are a little late in the game, but nevertheless, we are in the game now. So we're just waiting for the appointed day. I've heard in some circles that they will be effecting it probably sometime in the next fiscal year. So this is our legislation. And I just wanted to go really quickly through some of the data protection standards. A lot of it is very similar to what we have in the GDPR, but there are some differences. We acknowledge, of course, Jamaica becoming a more technologically driven society, one that's informed by certain digital considerations that also informed us moving towards enacting this Data Protection Act. There was quite a bit of discussion, especially in 2018 and that time, about our national identification system and what that would mean for us without a robust data protection regime. Are we just going to rely on our constitutional right to privacy, or do we need this data protection regime? So there are calls within the society for us to push through with that legislation. And now we see that we have it passed, and we are just waiting for commissioners to be appointed to the Office of the Information Commissioner, and the actual office to be established, and requisite persons there to ensure that we are ready for this act. And of course, Joanna will speak a little bit more about how businesses can get ready for the implementation of the act. So just some of the data protection standards. Data controllers, which are the companies that are required to comply with the Data Protection Act, are required to comply with these data protection standards. And if it is that there's a breach, there must be some notification to the Information Commissioner of any contravention. And if there's a possession of data in contravention of those standards, companies may face fines up for not exceeding 2 million Jamaican dollars or imprisonment up to 7 years. So the first standard is fair and lawful processing, which is a standard, a principle. I think the terminology in the GDPR is a principle that is found also in the GDPR. So generally speaking, personal data shouldn't be processed unless you get that consent from the data subject, if it's necessary for a contract with a data subject. So if you and I are contracting and because of this contract, we need certain information from you, that can be a fair and lawful basis for the processing. If the processing is necessary for compliance with compliance with a legal obligation which a data controller is subject, for example, your know your customer, anti-money laundering type of regulations, those are things that are applicable for the administration of justice, court documents, litigation, that type of thing. If it's in the vital interest of the data subject, or if the processing is necessary for the functions of government, or of course, if the data subject has published that data. Just looking very quickly at what consent means. We had a very, I would say a little weak definition of consent, but I was glad to see in the final version of the bill that we had a GDPR standard. I like to say it's the gold standard. I'm not sure if everybody agrees in terms of consent. It's one of the grounds to lawfulness of processing, and it's informed, specific, unequivocal, freely given expression of will, which the data subject agrees to the processing of that data subject's personal data. So informed meaning that that person needs to be informed of why you're processing it, how you're processing it, what exactly it entails before they actually give that consent. We don't have provisions in our law for withdrawal of consent like in the GDPR, but I think that if something is freely given, it can be freely taken. So I do believe that there is some implicit obligation as well for that. Purpose. We're familiar with this. Data controllers can only obtain personal data for one or more specified and lawful purposes, and it should not process data which is incompatible with the purpose for which it's obtained. There's a minimization. The personal data which is collected shall be adequate, relevant, and not excessive in relation to the purpose for which it is obtained. Accuracy, data shall be kept accurate and up to date. Storage limitation, you should not be keeping any data for longer than is necessary for the purpose of processing. In terms of timelines, those are things which will be determined in the regulations, which we haven't really received as yet. Compliance, which is sort of a catch-all provision, personal data shall be processed in accordance with the rights of data subjects under the Data Protection Act. Security this now requires data controllers to have adequate security measures in place to protect personal data. Of course, different companies will have different standards and different risks depending on the type of data you're collecting. So a lot of it will depend on the nature of the data process, the harm that may occur from unauthorized and unlawful access. And of course, there is an obligation to inform the Information Commissioner's Office if there's any breach of those security measures. And data transfer, personal data of Jamaican data subjects shall not be transferred outside of Jamaica unless that territory has an adequate level of protection for rights and freedoms of data subjects. Just want to point out here as well that our domestic legislation, the Jamaican Data Protection Act, not only applies to companies that are established in Jamaica, but also to companies that are processing personal data of Jamaican data subjects or targeting or monitoring, etc. So it takes into consideration that GDPR type of extraterritoriality. So we're looking at a sort of expansive, large reach of the Jamaican Data Protection Act. As to whether or not we have the enforcement mechanisms to do that remains to be seen. So just in wrapping up, the rights of the data subjects are a little different from our GDPR rights. We have a right of access to personal data. So if it is that you have a company that is processing personal data about you, you do have a right to query whether or not they are, as well as to ask for a copy of that data if you wish for a fee. If we are doing direct marketing, sending those text messages, etc., consent is required for that. Right to prevent processing of personal data, which may cause distress or damage. There's also that as well. So we don't have a right to be forgotten. Rather, what we have is that prevention of processing if there is distress or damage, as well as our right to request rectification of inaccuracies. So if something is wrong about you, you can say, hey, this is wrong information that you have about me. As well as you have some rights in relation to automated decision making. So you have a right to query the logic behind the automated decision making and know about all of that. So I have wrapped up. So if there are any questions, as Shamon said, I'll be happy to take them at the end.
Okay, thank you, Ms. Collins, for that wonderful presentation. It was nice to hear about the different standards and the rights, as well as the detailed background and history of the existing laws in Jamaica. At this time, I'm going to invite Ms. Cheyenne Hilson to introduce Ms. Joanna Marzuko. Ms. Hilson.
Thank you, Shamon. Good afternoon, ladies and gentlemen. It is indeed my honor to introduce our next presenter for this afternoon, Miss Joanna Marzuka. Joanna attended the University of the West Indies, where she graduated with a Bachelor of Laws degree with first-class honors and was awarded the Frank L. Myers Scholarship, established by Myers, Fletcher, and Gordon, to honor one of the founding partners of this law firm. She went on to obtain her legal education certificate at the Norman Manley Law School and was called to the Jamaican bar in December 2019. Joanna's practice areas include data protection, corporate finance, compliance, banking, corporate acquisitions, and general company law. At this time, ladies and gentlemen, I ask you to join me by putting your virtual hands together in giving Miss Marzuka a warm welcome in G2K style.
Hi, everyone. Thank you for having me today, and thank you for that introduction. Thank you to Justine for that presentation. Makes my life a lot easier going through everything so well. So you sharing my screen now. You can let me know if it's working. Are you seeing it now?
No, not as yet. It's not visible as yet.
Seeing it now?
Yes, we're seeing it now.
Okay, great. So Justine went through a lot of the high points for the Data Protection Act, primarily the data protection standards and the right to the data subject, which are all extremely important in guiding all of the viewers through my presentation. What I'll be focusing on is some of the ways to prepare, particularly in a commercial context, because the Data Protection Act and compliance with it is gonna affect your balance sheet. the time, the resources, the cost to implement is going to be something that we all need to think about, because most, if not all, businesses are going to be caught by the Data Protection Act. So these are some of the questions that businesses need to lend their mind to and that we'll be going through today. So just a quick recap. Personal data is really a data that can be identifiable to that individual living or somebody who has been deceased for less than 30 years. Do you process personal data? So the definition of processing under the Act is very broad, and it's for this reason why so many businesses, if not all, are going to be caught by the Data Protection Act, because we're looking at the collection of data, recording data, storing data, using data, and even destroying data. So the answer to do you process data is more often than not going to be yes. So one of the first primary questions you want to look at is, are you the data controller? So the data controller is defined as the person or persons who determine the purpose and the manner which the personal data is going to be processed. Notice that the definition does not say that the data controller has to process the data. But as Justine would have indicated, the data controller is who all of the obligations under the Act fall to. So a data controller then needs to bring their mind to, are they going to be processing the data themselves, or are they going to outsource it? Outsourcing is a possibility. And if you outsource, the third party that you outsource to is referred to as a data processor. Keep in mind that the obligations remain with the data controller even where processing is outsourced. Data controller also has an obligation under the Act to choose a data processor that has guarantees in respect to the technical and organizational security measures, security breach notifications, and they also have to ensure that this compliance is maintained. So it's not a case where you do your due diligence at the beginning and then you kind of wash your hands of it. The data controller must ensure that this kind of compliance is maintained throughout their relationship with the data processor. So the next set of questions that a data controller may want to ask themselves, and these are particularly important in guiding them throughout the rest of the process, is what kind of data do you process? How do you process the personal data? And what's the purpose for processing the personal data? At this stage, a data inventory is critical because the kind of data that the data controller processes is going to dictate their internal controls. It's going to dictate some of their obligations. For example, do you process personal data? Do you process sensitive personal data? Do you have health records? Things like that. That's going to dictate the organizational and technical security measures that you have in place, how you process that personal data. When you're doing a data mapping or a data assessment of your business, if you're able to do that, that's going to be able to tell you the gaps, the weaknesses, where you need to improve. It's going to show you how the data moves throughout your organization or even outside of your organization. And knowing how you process the data is critical to know the kind of systems that you're going to need to put in place, as well as anything that you're going to need to change. The purpose for processing data is going to be critical for you to know in looking at some of your obligations under the Act or any exemptions you may have under the Act. These questions are also very important when we're going to talk about consent again later, as Justine mentioned. It needs to be informed. The answers to these questions are going to be important for you to be able to communicate them to the data subject so that they're able to have a very good idea of what they're consenting to. Because if it's not informed, as Justine would have mentioned, it's not going to be considered consent. So the next question, one of the big things in the Act is the consent of the data subject. Consent is a legal basis for processing. I don't think we need to go through the definition again. The key points are informed, specific, freely given. like Justine said, informed means that they need to know how the data is being processed, what it's being processed for, the manner in which it's being processed. There are certain provisions in the Act that specifically require consent, like direct marketing. There's some exceptions if the data subject is already a customer of the data controller. Knowing exactly what consent is important for the data subject to prepare for the coming into effect of the Data Protection Act, because the data controller needs to know, do they have a legal basis for processing this data? Are they covered? Are they going to be in a position where they may be processing data in contravention of the Act? This is one of those very important things that they need to lend their mind to, and then to ensure that they have a consent clause that covers what they need it to cover. So one of the things that stands out to me in the definition of consent in the Act is the use of the word specific. So we take that to mean that when you're getting the consent of a data subject, or when you're seeking it, you need to be very clear on what it is that you're asking for, what it's going to be used for, the mediums you're planning on using. So this is a consent for the Guardian newspaper in the UK. And well, hopefully you can read it, it's a bit small. They have split up all of the mediums and the products and services that they're intending to use to send you this data. So to send you the promotional materials and the subscriptions and things like that. They also have different ways that you can receive it. I think it's email, and then you see at the bottom, they also have SMS updates. The last part is how else can we get in touch with you? So they have made it clear by separating, I do not want to receive communication by post, and I do not want to receive communication by telephone. So the way they have split up everything and made it very clear and very specific is an example of a nice way of letting the data subject know everything that you are offering, and then letting them choose and refuse what they do and don't want. So this is where I think we want to spend most of our time, is on the compliance requirements, because this is where a lot of the commercial decisions and commercial considerations are going to be made. So we'll start with the two on the left, the registration with the Information Commissioner's Office. Data controllers are required to register with the Information Commissioner's Office. So registration, at first seems like a pretty simple process, but the information that's required to register is where the data subject is going to have to take some time and possibly some financial resources, because it's going to have the particulars of the data controller, the nature of the personal data that they're processing, how they're processing it, giving the Information Commissioner kind of a snapshot of what they're doing with the data, the personal data that's in their custody and control. Somebody is going to have to do that. That's one consideration. Another consideration will bring us back to the beginning of the presentation with those three questions. What data are you processing? How are you processing it? And the legal basis for processing and the purpose for processing it. Those questions are going to become very important in this registration process. The other compliance type of report is a data protection impact assessment. So that's an annual report that's going to be sent to the Information Commissioner within 90 days of the relevant calendar year. This information is going to give another snapshot for that particular year of the personal data in the custody and control of the data controller. Again, somebody's going to have to do that. So whether it be that it's somebody in-house or if you're able to outsource, again, these are all commercial considerations that businesses need to be thinking about in preparation, because these are the kinds of things that are going to be need to be included in a budget in terms of finances as well as time. So the other two compliance requirements which I've pulled out are general processing in accordance with the Data Protection Act, which Justine would have gone more in detail on. And then internal controls are going to go hand in hand with that. So you're going to need to be, businesses are going to need to be thinking about things like, how am I going to process in accordance with the Act? What internal controls do I need? Do I have a privacy policy? Do I need to update my privacy policy? Is my staff trained? How often do I need to train my staff to keep them in the loop of new developments in data protection or the policies that I have in place at my, at my business? You need to be thinking about things like the technical and, organizational security measures. These are going to be antivirus software, things like that, passwords. It's a slew of different things that are going to assist a data controller to process in accordance with the Act and ensure that they're not having a breach. What is going to be appropriate for each data controller is going to be different. So I think it's very important that businesses understand data protection compliance is not a one-size-fits-all type of thing. There may be checklists and there may be, particular things that are going to apply to every data controller. But how it's implemented throughout your organization is really going to depend on size, nature, industry, particular requirements that you may have under other acts. So for example, Justine would have mentioned, financial institutions, they have particular AML requirements, and, lawyers as well have particular AML requirements. There's going to be retention of data that we all, some particular industries may have that others don't. So while there's going to be, there's a nice framework that a lot of businesses can use, it's very important that the policies and procedures that you implement in your particular organization are well suited for what you are, for what kind of data you're processing and the way that you're processing it. So another compliance requirement that I wanted to pull out was the appointment of the data protection officer. This is not for everybody. There are particular data controllers that are required to appoint a data protection officer under the Act. Public authorities, those processing sensitive data, those processing data on a large scale. Although appointing a data protection officer is not a requirement for all data controllers, it's good practice to have a point person, somebody in charge of, compliance, a point person for data subjects to contact if they, if they want to access their data, if they have a complaint of any sort, things like that. Again, while this is a good practice, very helpful to the data controller, it's also another commercial consideration, because that's going to either be another salary on your payroll or additional tasks for an existing employee, and that's a time resource. So these are all things that think about, what's going to suit you, what's going to help your business to keep your business in compliance with the Act. So again, so we're at the penalties now, which is usually the part that most people are going to be concerned with, because the potential penalties under the Act can be very hefty. I think Justine would have mentioned one that's within the Act. So there are other penalties for particular sections, breach of those particular sections, but there's also the general catch-all, which is the fine not exceeding the 4% of annual gross revenue, worldwide income. The director, manager, secretary, or similar officer can be found personally liable. And then there's also where a data subject can prove that they've suffered damage by reason of a contravention of the data controller from their obligations under the Act, they may be entitled to compensation. So while the penalties are very hefty and extremely important, they're not the only things that a business should consider when putting their mind to data protection compliance in a commercial context. You want to also be keeping in mind brand reputation, their position in the marketplace. There have been a lot of studies, I think a recent one by Forbes in the last couple of years, about the effect that a data breach can have on the reputation of a company. And I think it's in the range of 40 to 45%, and even 20 up to 20% where it's a breach by a third party third party could include that data processor that you may or may not have outsourced to. On your bottom line, you also want to be thinking about share price. So last year or the year before, Forbes did another study that data breaches can have an effect of on average 7% of reducing the share price of a company. So with all of these, compliance requirements and preparations that are going to help you put yourself in a position to be ready for the act. Data controllers want to put themselves in that position sooner rather than later, because it's going to affect your budget. It's going to affect your resources. It's going to affect the way that we do business generally. So we have a 2-year transition period under the Act. I would say, let's not wait, especially if resources are going to be a bigger issue for some data controllers than others. So these are just some of the things that data controllers may want to start lending their mind to in order to prepare and do what they need to do to get themselves in compliance with the Act, so that they're not facing any of these penalties or any of these reputational risks or anything of the sort. So that's it for me. I guess we'll wait till the end for any questions that anyone may have.
Okay, thank you, Joanna, for that very informative presentation. I believe learn about compliance and the penalties is something that is very important at this stage. At this time, we're going to have a short break, and we'll have Miss Catherine Smith, who is a very talented member of the G2K Foreign Affairs Committee. She'll be doing a violin performance for us. Okay, we seem to be having some technical difficulties on Miss Smith's end. However, that was still a very wonderful performance, and we thank her for that. At this time, I'm going to invite Mr. Amour to do a giveaway. Mr. Amour.
Greetings, everyone. Greetings, everyone. And thank you for that performance, Ms. Smith. She is actually a member of the committee, and she has been giving us these beautiful renditions ever since the beginning of the forum, and we hope to hear some more from her. She's available for bookings, so you can find her on her social media platforms. I'm sure that she can bless the hearts of persons at their weddings, graduations, or any other function. So we're at the fun part, the giveaway part. On the final day, we'll be announcing the winners of the giveaways from the 3 days. So today, the giveaway question can be answered via Instagram, it can be answered via Twitter, and it can be answered via YouTube. So the giveaway question, the first giveaway question is this: which law firm does Justine Collins work at currently? So that is the first question. And that can be answered via all these platforms. For YouTube, you can comment the answer. For Instagram, you can say the answer at the page, and on Twitter, you can at the page as well. This next question can only be answered after subscribing to the G2K YouTube channel and answering in the comment section. So this question is, name 2 members of the G2K Foreign Affairs Committee. Okay, Shamon, I hand over back to you.
Okay, thank you, Mr. Amour. So we're going to go back into our presentations, and our next speaker is Mr. Matthew Saizi, and he'll be introduced by our committee member, Sandra Rodin. Okay, ladies and gentlemen, we seem to be having some technical difficulties. I'm so sorry about that. However, I'll be doing the introduction for Mr. Saizi. So Matthew Saizi is a Kenyan qualified lawyer with an LLM in computer and communications law. He currently specializes in data protection and cybercrime and serves as a certified information privacy practitioner. He has worked with various organizations, including Microsoft and OneTrust, and presently acts as privacy counsel at Mott MacDonald, an infrastructure and development consultancy headquartered in London. He also has a passion for mentorship and youth engagement. Ladies and gentlemen, can you help me in welcoming Mr. Matthew Saizi?
Thank you for that, Shamon. I hope you can all hear me well. Just give me a prompt if I'm not coming through clearly. Thank you so much for the person who's playing the violin. I really enjoyed that. I've not come across that before. So very quickly, in the interest of time, my name is Matthew, and most people call me Matt. I'm Privacy and Data Protection Counsel for Mott MacDonald Limited, an infrastructure and development consultancy based in London. And I primarily sort of deal with more of the commercial aspects that have come around as a result of the change in legislation which was preempted greatly by the GDPR. So we'll talk a little bit about that. My presentation today, and I understand Shamoun, someone will be sharing those slides. So if you could please throw those up.
One moment, please. We are trying to get them up for you.
No problem. Sorry, just bear with us, people.
Hey, could you please bear with us, ladies and gentlemen? We're currently having some technical difficulties. It's very rainy here in Jamaica, so we're trying the best we can at this time. So we'd appreciate your patience.
Shamoun, shall I just try and do that directly on my side? That may help things.
Yes, I'd appreciate that. Thank you.
Okay. Let's let me get that set up. Okie dokie. Can everyone see that?
Yes, we're seeing it.
Okay, so we'll have to share this on presenter view, but essentially my topic today is understanding the framework around data protection, and I thought I'd focus on the international outlook of privacy and data protection, kind of go into the history of how privacy and data protection has come about and where we find ourselves in 2021 with what looks like a very complex international system of privacy and data protection. So going into the history of it, privacy and data protection sort of emerged organically from two different spheres. You know, you've got the multilateral trade agreements, and you've got, you know, international human rights conventions. So for instance, the WTO had rules that affected data flows under GATS, and that covered sort of digital flows of personal data, you know, the Trans-Pacific Trade Agreement, and the OECD issued guidelines, and OECD obviously focusing on economic cooperation and development, sort of issued guidelines around the transferring of data between different members. Now, just as I believe it was Joanne who said, it's going to affect your bottom line. And the reason why it's so important, privacy and data protection is so important here, is because it's revenue. I think we've all had the expression somewhere that data is the new oil, right? And so it's become apparent to most organizations and to most governments that it's very important to take care of this personal data. So you could look at it as very important for companies from a commercial aspect to have this data and to make sure that it's secure, and for governments to ensure that individuals or members' personal data is sort of well taken care of. So on to the next slide. In the hullabaloo of all this going on, in 2018, there was a very unique piece of legislation called the General Data Protection Legislation. Now, this happens to be one of the toughest privacy and security laws in the world at the moment. What happened is the Data Protection Directive, which was enacted by the Council of Europe was sort of ramped up into a regulation. So when you're dealing with EU law, you kind of say, okay, look, a directive is something which has to be transposed into national law, but a regulation is a copy pasted into existing local law. And so that's what it did. Now, it had very unique elements around it, some of which I'll talk through in this presentation. One of them being the fact that it had a material and territorial scope. Now, the material scope of the GDPR essentially is anyone processing personal data or data that forms a part of a filing system. So sort of bringing in that traditional, cabinet and files system of processing data here, and the electronic version. So everything from sending out marketing information and so on and so forth. And most importantly, a territorial scope. So it became either you are located outside the EEA and targeting EEA individuals, or you're processing this personal data within the EEA. Now that becomes very important, especially when you merge it with another aspect of this, which is the very harsh penalties that can be enforced on organizations. So say you are a Russian law firm who was selling goods in Germany and France. Now you may not even have an office in Germany and France, but people are able to access your website from Germany and France or Italy. And so you fall under the scope of the GDPR. Now some of these penalties quite high. In severe cases, up to 4% of revenue for that year, or 20 million euros, whichever is higher, or in the lesser cases, 2% or 10 million euros. So something very, very concerning. And I'm sure if you're keeping up with the news, you'll see a lot of companies being fined. They start with the big tech companies, your Googles and your Facebooks, and all the way down to, I saw in Belgium, just a local plumbers company being fined almost 30,000 euros because they wouldn't stop sending marketing emails, right? So again, like it's been mentioned by some of the other speakers, compliance with privacy and data protection laws really does affect your bottom line. Remember, if you're a business person, you can't be insured against fines and penalties, and you essentially have to pay that fine out of your own pocket in most cases. Now, another really important aspect of the law was it defined sort of this controller and processor relationship. Now, that's unique because essentially the law says under Article 28 that there have to be mandatory clauses. Now, these are a whole list of clauses, and that's why GDPR, as the first speaker mentioned, is almost every law firm around the world is quickly setting up a privacy practice, because Article 28 says that there are mandatory terms which have to go into contracts between controllers and processors. Now, again, this is quite unique, I think, to the GDPR, because most other legislations don't. Most other legislations have a general duty to comply or a general obligation to institute terms, but the GDPR, and what is now the UK GDPR after the Brexit, gives you mandatory requirements like, it must be written, there must be a duty to audit, an obligation to assist, an obligation to report breaches, and those kinds of things do affect, do have a commercial implication to them. It contained principles, and I believe Jamal is going to speak about the principles of the GDPR after this. And most importantly, individual rights requests became mandatory within relationships between, remember, controllers and processors, and also sub-processors, right? Again, with this sort of theme of international regulation and cooperation between different states, at the EU level, there were bodies like the European Data Protection Board and the EDPS, which is the European Data Protection Supervisor. So bringing in supervisory authorities by the different member states at a place where they could collaborate and make sure that the laws that are being enacted by the European Commission are being rolled out sort of correctly. And then bringing novel concepts like the one-stop shop mechanism, right? So it's a very robust and I think what we call it's the gold standard in privacy and data protection regulation. And so the ripple effect from this, and one other aspect was international data transfers becoming having very detailed specifications about sending personal data outside of the European economic area. And we'll talk about that in a couple of other slides. So what was the net effect of this? The net effect of this is this sort of mushrooming of loads and loads of different privacy laws, the Singapore PDPA, the CPRA, the POPI, which was there before the GDPR, but some of the provisions had been made dormant, the Turkey Data Protection Act, and so on and so forth, everywhere from Bahrain to Kenya, lots of different countries showing, and there's a map of put up on the screen there showing now what the privacy and data protection landscape sort of looks like. So almost entirely covered. Now, a lot of these laws, I think it's worth noting, will mirror closely the GDPR and the definitions therein. I believe it was one of the other speakers talked about the definition of consent being an ambiguous, informed, explicit, and freely given. Now that's almost word for word what you find in data protection law here in Europe and in the UK, sort of being transmuted into many different countries and countries like the developing world. So again, in keeping with the theme of this symposium, why is this relevant? For promoting international cooperation or for promoting trade. Because essentially now what we have from a commercial legal standpoint is you have a need to demonstrate compliance, right? So no one is going to come and tell you this is what you need to do. So maybe in the case of, I've seen with Turkey, when you're registering, you might need to set out your process in a detailed manner, or you might need to report to the regulator on a monthly basis, as in the case of countries like Bahrain. But in most cases, what you'll need to do is you need to comply. And if the regulator should come knocking because somebody has made a complaint to say, look, I suspect these guys have my details and they've been sending me messages to purchase their sneakers, you need to be able to say, look, no, we don't have this. We have a consent framework in place, and it's your responsibility to demonstrate that compliance at the risk of you facing some rather serious sanctions. So the last aspect of the GDPR, and it's not just an aspect unique to the GDPR or the UK GDPR, is international data transfer. Now, this is a whole can of worms. And it's like we've said, for countries to be able to trade or to be able to do business together or to engage in, large-scale infrastructural development, like some of the matters I've advised on, privacy and data protection is now a massive consideration. You've got a sort of a GDPR now, on the UK GDPR now saying things like, look, transfer data to third countries may not take place unless, one, that country has a similar level of compliance to ours. So say that's what the law in Europe says, or the law in England says. And I've had a quick look at the Jamaican Data Protection Act of 2020. That's what it says. So say Jamaica was trying to do business with the United Kingdom, and there wasn't an agreed sort of framework for transferring of personal data, right? So say, for instance, you find yourself in a scenario where a UK firm, say, would want to consult with a body of the Jamaican government, right, around education of young girls or a new prison system. And that would involve interviewing young people or people at risk and collecting lots of special category or sensitive personal data. that may present some challenges, right? And it may be, you end up spending months in a boardroom trying to work out the finer points of how are we going to protect the individual's rights within this agreement, because like I mentioned earlier, you've now got commercially enforceable individual rights. Okay, if a farm in Jamaica happens to lose or leak or have a data breach that loses personal data of Jamaican citizens, who's going to be answerable to that? Is it going to be the Jamaican Data Protection Authority? Is it going to be the ICO? So international data transfer very quickly would be, you can do that in the case of adequacy. Also, they have an agreement if there are appropriate safeguards. So that could be a legally binding instrument. You may see that in cases, let's say, between the law enforcement directive or something like the Five Eyes directive, where enforcement agencies share information for national security interests. Binding corporate rules in commercial organizations. What that means is it's essentially a sort of a document submitted to a regulator that's approved. Standard contractual clauses, which are used sort of tacked on the back of commercial agreements, which set out the responsibilities of the controller and the processor, and have other commercial clauses as standard. For instance, liability clauses and indemnity clauses, which do affect your sort of bottom line. These are very serious points that affect how companies do business, on the basis of maybe a one-off transfer with a special interest. And then, of course, there's derogations, where it's not necessary to comply with data protection law or with the GDPR, in the cases of defending legal claims or public interest or in vital interests of the data subject, which usually means life and death. Okay, so thinking about all that, there may be other countries where there are restrictions to sharing personal data, like we've talked about, with that maybe consent is necessary. As you see with a lot of countries in Southeast Asia, your Malaysias and your Thailand, a lot of people, a lot of times the law will simply say there must be consent from the data subject. So thinking about the privacy notice that Joanna was talking about, sort of lending to a concept called data protection by design, where you essentially have to think about the project and the processing that you're going to do before you carry it out, so that you're able to comply with it from beginning to end. And the other countries where there's data localization requirements, places like Russia, you're unable to share financial information outside the country. Places like China, which I think 2 days ago has now given us the second bit of their privacy law, which applies to critical infrastructure. So it's all very interesting, and it's all very, very relevant to the theme that the symposium is intended to discuss, which is, how do we promote trade? How do we secure international cooperation? We're almost at the end, but aside from the GDPR, there might be other bespoke mechanisms for sharing personal data. You've got your Council of Europe Data Protection Convention, and that's open to anyone outside the Council of Europe to join. That could be what you're relying on. The EU-US Privacy Shield, which we know after a case called Schrems 2 was declared invalid, but is still valid for, say, the US and Norway, because that's an EEA country. You have your Asian data management framework, or your Asia Pacific Economic Cooperation. They have their own sets of clauses and cross-border privacy rules for sharing personal data. And this all seems to be fostering a culture of sharing personal information, right? You've got private companies like Google and Amazon giving massive infrastructure support to governments. You could be having a hospital, say, I'll keep using the example of Jamaica because I'm conscious of the audience, but you could have, say, a hospital in Jamaica having its entire back system or backup of data and prescription and all that being hosted by Amazon Web Services, and that personal data is being stored, say, in California, right? And so when you're negotiating that from a commercial standpoint, what you want to be thinking about is, hang on, who's going to be responsible? Who's going to have access to this information? Can we audit this information? Will we be able to call on a data protection breach notification arising in that country? Is it subject to the right technological and organizational measures, like Justine mentioned earlier? And so that's just a bit of a flavor about what's happening in the world and what the framework looks like from a privacy practitioner's or from an international relations point of view. And I threw in one tiny little scenario here just to give you concept of how this applies in the real life use case. So a UK firm may be contracted by the Ministry of Education in South Africa, so the POPIA applies, to carry out a specialized survey of children between the ages of 12 and 15. You know, the project could be funded by the World Bank Group, right? Which again makes it that much more complicated because the World Bank isn't subject to any particular national law. It's a treaty organization. And a report of these findings, you know, would be shared with this donor. And this report could contain some case studies, so named individuals, as well as pictures and emails of the survey activity. Now, while carrying out this survey, the UK firm that's been contracted could get local sub-consultants to carry out the field work. And because we're dealing with children here, the local firm may be responsible for safeguarding, which, as we know, is, you know, the protection of vulnerable groups. So if somebody is being abused, how is that information going to be collected and reported and so on? So I feel like it's a very relevant topic and it's a very interesting thing. We won't go into it for the interest of time. I know at the beginning of the presentation, there was quite a lot of technical delay, but I think that's just a bit of a flavor as I see it and sort of an opener. And then, of course, you've got individual rights at the back of it. What might you want to consider in that scenario? You know, how this information is received, processed, and how it's sent, and having on the back of it a framework for reporting personal data breaches. I think I'll stop the presentation there at the risk of losing you. And I think that's right on the minute for time.
Okay, thank you, Mr. Sazi, for this brilliant presentation. You've taken an area which would be very complex to the layperson. You've simplified it, especially with the help of your scenario, and we are very grateful for that. We'll now like to invite Ms. Yetunde Oke to introduce Mr. Jamal Hamad.
Good afternoon, everybody. I have the pleasure of introducing Mr. Jamal Ahmed. Mr. Ahmed is a fellow of information privacy and CEO of Kazient Privacy Experts. Jamal is an established and comprehensively qualified privacy professional with a demonstrable track record solving enterprise-wide data privacy and data security challenges for small businesses through complex global organizations. I apologize, for SMEs through complex global organizations. Jamal is a certified information privacy manager, certified information privacy professional, certified European Union GDPR practitioner, master NLP practitioner, Prince 2 practitioner, and holds a Bachelor of Arts in Business with Law. He is a revered global privacy thought leader, world-class trainer, and published author for publications such as Thomson Reuters, The Independent, Euronews, as well as numerous industry publications. Jamal makes regular appearances in the media, on television, on radio, and in print, and has been dubbed the king of the GDPR by the BBC. To date, Jamal has provided privacy and GDPR compliance solutions to organizations across 6 continents and in over 30 jurisdictions, helping to safeguard the personal data of over 1 billion data subjects worldwide. Everyone, please join me in welcoming Mr. Jamal Ahmed.
Thank you very much, Yatunde, for such a kind introduction. And it's my pleasure to be speaking to you from the comfort of your own house, the office, or wherever it may be, and wherever you are in the world. To the Jamaican audience, Watagwan, it's my absolute pleasure and an honor to be here in front of you today to talk about data protection and data privacy. Data privacy is the hottest industry in the world right now. We see that 10% of the world has data privacy laws in place right now, and it's estimated another 50% of the world are actually going to have that in place in 2023, which means that we can see that the industry is going to go boom. So it matters for two different reasons. So over the course of the next 15 minutes or so, I want to get across three things. Number one, I want to explain why does this matter? Why has the whole world gone bonkers mad over data privacy? What is the difference between data privacy and data protection? So that's the first thing I want to cover. The second thing I want to cover is why does this matter? Why does it matter from a business and an organizational point of view? And why does it matter from an actual personal point of view and to the individual? And finally, I'm going to delve into the principles of what I use to guide myself, whichever company I'm working with, wherever they are in the world, to make sure that we can help them to make sure the things that matter that we're going to discuss at the beginning are actually put in place to safeguard their reputation. So first of all, let's have a look at what is the difference between data privacy and data protection. We all know data protection, there's data protection laws in the UK, we've had these, we've talked about the directive, but then when it comes to actual privacy professionals, why are they not called data protection professionals? Why are they called data privacy professionals? What is privacy? What is protection? So I'm going to tackle that first of all. So let's get started with it. What is privacy and what is protection? So what I want you to do is I want you to imagine you're coming home from work. And when you get to your front door, you have a lock and a key to open that lock. That's the protection. That protects people from entering your house to take away your valuables. You have protection to stop people from coming in, right? That's your security there for the protection. That's what data protection is. So what is privacy? Now, when you get inside the house, you have these transparent windows, depending on where you're in the world. Some people don't have windows, but you still have transparency where people can see into your house. And you have valuables at home. And then sometimes you don't have valuables, but you have things that are quite personal to you, some things that are quite intimate to you. And you want to stop other people from seeing your valuables and seeing those things that are quite intimate and personal to you. And that's what data privacy is. So if you think about it in your own house, you have data protection, you want to stop people from coming in, and you might have layers of protection. So you might actually go in another room and then be a separate door. And then in that room, you might have a safe for some things that you hold very dear. So that's what protection is, keeping it protected, stopping someone else from coming in. And then if they do get in, stopping them from taking it away. That's why we have additional layers of protection. Data privacy is stopping them from seeing it to begin with. You want to stop them from seeing when you're getting changed. You want to stop them from seeing all of the valuables that you hide. You want to stop them from seeing all the personal, intimate things that you're doing. And that's why data privacy and data protection come together. Because without protection, and you can't have privacy. And without privacy, it becomes very difficult to have protection. So that is the main difference between data protection and data privacy. And data privacy is seen, especially in Europe, as a fundamental human right, because we as individuals, we need that privacy. So think about it. We just had the example of you in your own house. Even in your own house, you have different rooms, you have walls and you have doors to separate that. When you go inside the bathroom, you have a door to separate you to keep you private. And even when you get into the shower, you will have a shower curtain to enhance your sense of privacy, right? So privacy is something that is fundamentally important to the natural person. And the European Union recognizes that, and that's why it was enshrined in the basic charter of the Fundamental Charter of Human Rights. And our friend Matt actually spoke in quite a lot of detail about that. So data privacy, data protection, we now know what the difference is between those two are, and we're going to see why and how they come together when we move to the principles. Now, let's have a look at why does this matter? So there's 5 key reasons I've found in my travels across the world why this matters. Number 1, businesses really care about this. Stakeholders, senior shareholders, people at the board, they really care about getting it right because they don't want to ruin their reputation. companies work for years. They spend so much money on PR, marketing, building up employee culture, values to get that reputation that we are great at what we do. You can trust us. The moment there is a data breach, and now we see that the world's media is more than happy to publish those, we see businesses suffer significant losses from the damage to the reputation. And trust is something that it takes years to build, and it takes a moment to lose that trust. Let's take a look at the example of Facebook. A few years ago, when the GDPR first came along, Facebook was found to not to comply with the regulations. It was found not to hold on to people's privacy. So what did the regulators do? They fined them £500,000. That £500,000 took them 8 minutes to generate. But the reputational damage they suffered meant that 1 in 3 people in Sweden shut down their Facebook accounts. And because those people are not seeing those adverts, the share price went down, and also the revenue they was generating went down significantly. And if you look at the examples in the UK of how this really affected TalkTalk, it is a prime example of how a business cannot afford to take a hit on its reputation. So that's the first reason why it matters so much. And I find that most businesses and most individuals who run businesses or are in charge of managing businesses, they want to safeguard their reputation. So it's very important to get it right. The number 2 reason why it's very important is it touches on the reputational damage. Is when you have reputational damage, it's because you've been issued with a fine. Once a business is issued with a fine, they have to get that money together, which would otherwise be used for other purposes. Nobody has spare money lying around to pay those fines. And even if they do have spare money lying around, it's better off spent investing in the business or going to the shareholders. Nobody actually wants to take that money and pay fines with it. And as we've seen, these new privacy acts all over the world increase fines to 4% of total annual global turnover, or 20 million euros, whichever is larger. So that's significant. So that's the second reason why it matters to organizations. The third reason it matters is they want to build customer trust. When you show your customers you care about their right to privacy, you want to safeguard and look after the information they hold dear, you want to look after their personal data, customers are more willing to trust you. If a customer trusts you, they're more willing to recommend you, and they're more willing to do business with you and give you their money. Customers speak with their wallets. So you want to, businesses or across the world want to build customer trust. And if you want an example of that, what I want you to do is I want you to look at adverts. I want you to look at adverts by some of the biggest companies in the world. And these guys spend tons of money on their market research, right? So Amazon, Apple, these are some of the biggest companies in the world. They've stopped talking about their features. They've stopped talking about their prices. What they're selling, what they're taking billboards to sell is how much they value your privacy. When the new iPhone was released, in bus filters across the UK, you drove around and you saw the iPhone picture and saying iPhone privacy by default or privacy protected. There was some kind of an advert. So they're taking space just to tell people how important privacy is. That means 2 things. Number 1, that there has been a paradigm shift, and the individual actually cares about privacy more now than they've ever done in the past, and they're making decisions based on privacy. And number 2, organizations get this and they understand that people actually are starting to pay attention. And if we don't get this right, we could really lose all of our customers, or a huge percentage of our customers. And there is a study you can read about on one of our blogs, which says that 63% of people actually said that when it comes to making a purchase online, they're more worried about the privacy of their information over the specification of the product. So what that means is people are more likely to buy a laptop, for example, that has lower specification from a business who is more able to demonstrate that they're going to look after that customer's personal details, their email address, their credit card, over the company who they don't feel cares about the company, but offers a higher spec laptop for the same price. And that is huge for anyone who wants to think about it from a marketing angle. So that's reason number 3. Reason number 4 is all about employee trust. So your employees are the people who run your business. It's important that your employees feel like, yes, we are a company that does the right thing. We can be trusted with people's data. I can trust this business with my data. When your employees lose trust in the organization, they lose trust in the management, then you've got real problems, because these are the guys that are going out there, and these are the guys that are talking to their friends, talking to their families, talking to your customers. So if you don't have the employees' trust, then you're in a real big trouble. And finally, the fifth reason is operational disruption. If things go wrong, and it's not a matter of when, it's not a matter of if, it's a matter of when things go wrong, you want to make sure that you've actually put enough things in place to avoid operational disruption. If you cast your mind back to the Brexit votes in the UK, we saw images on the news of the ICO raiding offices of Cambridge Analytica and taking away their computers, taking away their systems. How successful do you think your business is going to be if you have the enforcement, the supervisory authority coming in and taking all of your equipment away? So that's the top 5 reasons why it matters. So we know what data privacy is, we know what data protection is, we know why it matters. We know why it matters for business to get things right. So from a business point of view, they want to make sure that they focus on the protection. They want to stop people coming in and stealing their data. They want to stop people stealing their secrets. They want to stop people taking away their customer data and selling it on the dark web. And as an individual, you want to make sure that when you hand your information over to the business, they keep it private. They stop other people from seeing it. Nobody should see your personal information unless they have a genuine need to. Certainly anyone outside the organization shouldn't get access to that. So that's data privacy and data protection, why it matters. And now I'm going to talk about when I'm going around consulting for businesses, when I'm helping people all over the world to comply and put in place privacy frameworks, and they're all around the world and they've got 30 different jurisdictions they need to comply with, how do I actually go around and make decisions and offer solutions without going bonkers? And if you're an aspiring privacy professional, or if you're quite new to this, or even if you've been doing data privacy for a time, but you haven't had a chance to implement a framework across the globe for multinational corporations, it can get quite complicated. So at this point, what I rely on is the data protection principles. And those principles are in the GDPR, but they actually derive from the OECD guidelines. And the OECD guidelines, for any of you who are not familiar with it, I would recommend you Google it. There's not enough time for me to go into it now, but there's about 30 different countries that have signed up to this cooperation for economic development. And they want to have free flow of data across all of these countries, because the more easily data flows freely, the more easily we can do business with each other. And if you want to do business with the European Union, if you want to do business with the UK, you need to make sure as a business, as a country, on a national and an international level, you get your data privacy right. You get that basic human right to privacy protected, and you make sure that it's embedded in everything that you do. And that's why we talk about privacy by design and privacy by default. But that's a conversation for another time. So look, it's been an excellent session so far. I've got one more thing I want to share with you guys, and then I'm going to go over to the question and answers. But if you've stayed around and you stuck around this long, don't go away. I've got some great stuff to give away, so you can actually take something away with you. And I'll come on to at the end of this. But I want to really congratulate you for making it all this way so far. And the final thing I want to tell you about is the 7 principles of data protection. And my colleagues, Chris, he spoke about all the US laws and the international laws. Justine spoke about the Data Protection Act, and I started explaining some of those. Joanne really started explaining the nitty-gritty and breaking it down for us all to understand. And Matt gave us such a great education in the 15 minutes that he was on. And that is a skill on its own, condensing that much information into such a small space of time. So you guys have actually benefited from some great speakers and some great takeaways. And what I wanted to do is tie all that together, break it down for you in a way you understand, so you have something tangible to take away with you as a result of coming to this session and investing your time and your energy to really be attentive. So pay close attention to the 7 principles of data protection. The first principle is all about lawfulness, fairness, and transparency. By lawfulness, we mean if you want to process personal data, then you have to have one of the 6 lawful bases for processing. So it could be because you have to do it for the fulfillment of a contract. Someone's bought something and you need to deliver it. You need to process their personal information about their address, etc., to make sure that they get what they've paid for. So it could be for a contract. It could be because you have a legitimate interest as a business to do that thing that you want to do. It could be because there's a vital interest and you need to keep that person alive. It could also be because it's in the public interest. There is a public interest in this, and that's why you're relying on that. And finally, it could be because you're relying on consent. And consent is when you say, I'm not going to process any personal information unless the individual who this personal information belongs to has actually said, it's okay for me to do that for the purposes I've told them I'm going to do it for. So that's lawfulness. Fairness is all about thinking about how necessary is this processing, how proportionate is it, and is what we're doing fair? And what I like to do is I like to think about this scale. And one of my peers in data protection actually discusses this at length on the podcast, and I'll tell you more details about that in a minute. But when it comes to fairness, what you have to think about is this imaginary scale, right? So on one side, you've got cool, and on the other side, you've got creepy. So we're talking about processing of personal data. If it's cool, that means people are okay with it. They think, yeah, it's cool what you're doing with my data. And then on this side, you've got this creepy spectrum. It starts getting a bit creepy, like, I didn't sign up for you to do that with my data. I didn't even know you was doing it. So we have to make sure that we have a balance, and what we're doing is fair on this cool to creepy scale. And finally, the third part of the first principle is all about transparency. And that's about being open and telling them, hey, this is the information we're going to collect from you. This is why we're collecting it. This is what we're going to do with it. This is how long we're going to do it for. This is who we're going to share it with. And when we do share it, this is how we're going to protect it. And if you don't like any of those things, you can get in touch with us and you can tell us about it, and you can exercise your rights. And even then, if you are still unhappy, you can complain to a regulator. So transparency is about being open and telling everyone what it is that you're doing, what are their rights, what can they do about it, what are you going to do with their data. So that is the first principle. The second principle is all about purpose limitation. So this basically says, look, if you're a data controller, then you have to only collect the minimum amount of data that is necessary for you to fulfill the purpose that you're trying to do. Now, it's very common when we go around the world, when we go around different businesses, we see forms and they're collecting so much information. And I'm like, hey, why are you collecting that? Oh, just in case we might need it one day. So we got to get away from that culture. We can't just collect information just because it's nice to have and just because it might be useful one day. We have to limit the data we collect to only what is absolutely necessary for that specific purpose. So that's purpose limitation for you. Sorry, that's data minimization. Purpose limitation is saying if you're going to do something with that data, then you can't do something outside of that. So if I collect your data to process an order, then I can't do anything else with that data unless I actually told you about it by following the transparency principle. I can't now use it for another purpose. So that's purpose limitation. That's the second principle. I've already explained the third principle, which is about data minimization. And the fourth principle now is all about accuracy. We have to take reasonable measures as data controllers to make sure that the data we keep or the data we collect is actually accurate and up to date. How frustrating is it for customers when they call and you've got the wrong address or you've got the wrong email or you haven't updated some information? So we need to make sure that there is value in the data that we hold. And the only way there's going to be value in the data that we hold is by having it accurate. Now, a lot of businesses will actually be assessed on how valuable the data that they hold is. We all know data is the most valuable commodity of our times. It is not oil, it is data. And therefore, we want to make sure that we keep that data as accurate as possible. So we increase the value that we have in the data and we increase the value of the organization. That is accuracy principle 4. The fifth principle is all about storage limitation. That means that we shouldn't keep data for any longer than necessary, and we should only keep it for the purpose for which it was collected. And once we're done, whatever it is that we've done with that, then we should now delete or destroy that data. So it's no longer held. The sixth principle is all about integrity and confidentiality. So we need to make sure that there's appropriate security during the processing of the data to protect against any unauthorized and unlawful processing and against accidental loss, destruction, or damage. And we can integrate some technical and organizational measures. So by technical measures, what are we talking about? So we're talking about solutions that you can actually buy software as a service. So for example, you might have a technical solution where you require passwords or you have everything encrypted. You might have an organizational solution where you have a policy framework. So we can have both technical and organizational measures, training, all of these things can really come into helping you demonstrate that you have integrity and confidentiality in the data. And confidentiality means that anyone that is unauthorized or anyone that doesn't need to see that data should not see it. So just because you have 50 employees in an organization, not all 50 employees need to see all the customer data on a database. Some of them will only need it for a part of the process, others will not need it at all. So you need to have good identity and access management systems in place to make sure that you're protecting the confidentiality of that data. And finally, we have the principle of accountability. And accountability is basically what gets law firms setting up data privacy teams all around the world. It gets people like me and you a career in data privacy, because businesses, data controllers all over the world have to demonstrate and evidence that they are actually doing all of the above. They're following the principles. They're doing what they're supposed to do. So data controllers have to carry out processing relevantly by complying with all relevant laws, and they have to demonstrate compliance with the laws. And that's where privacy professional comes in, and we help them with data protection impact assessments. That's where we identify the risk from a process or a processing activity that the business wants to take on. We talk to them, say, look, these are the risks, and this is how we can mitigate against those before you start the practicing. Records of processing activities. That's a log of all the information of personal data that you're processing. So you can put all of that information and understand where personal data is in your business, how it flows. Once you've mapped that data, you can then be transparent about it. You can then protect it. If you don't have any idea about where the data is, how it's collected, where it flows, which systems it lives in, who it's shared with, there is no way you'll be able to protect that data and keep it private, because you don't even know what you should be protecting, from what threats, and how you're going to keep it private and from whom. Then we also have so many other ways of demonstrating these accountability principles. You have policies in place, you have subject access requests. We have so many things that I don't have time to go into right now, but we can talk about those at a different time. Or if you're really interested, what you can do is you can start reading about all of the different things and all of the different ways of applying accountability when it comes to processing GDPR. So that's the final section of what I wanted to talk about. So we know the difference between privacy and data privacy and data protection. We know why it matters, and we understand the 7 principles that we have to follow to guide us in every decision or every solution that we speak about to the businesses, anyone we propose solutions to. Now, I promised you some giveaways, and I promised that I'm going to make it worth your while to come through to the end. So look, the first thing I want you to do is, if you're an aspiring data privacy professional, I want you to tune in to the Privacy Pros podcast. And the Privacy Pros podcast is a podcast that I host with my co-host Jamila, and we interview top privacy professionals from all over the world to share their tips to success, to have discussions on ongoing matters. And they will actually come and give you some practical advice and help you think about things in a way that you've never even thought about, from different industries and from different parts of the world, to really help your practice as a privacy professional. It's been ranked the #1 data privacy podcast by Whelp magazine, and it's been ranked the #3 top GDPR podcast of 2021 by Threat Technology. So it's the Privacy Pros Academy podcast. Make sure you tune into that. It's absolutely free. Let us know what you think. It's gone out to 50 countries across the world already. And if you're watching now, then it means you're in the best place to be able to hook that up. We'll put a link to it in the comments so you can actually get hold of that. The other thing you can do is you can join the Facebook Privacy Pros Academy private group. And in that group, I come on once a week and I do a free training every Friday at 6 p.m. UK time. And I talk about all of these different privacy matters, and I break it down for you and I make it easy so everyone gets it in a way that makes sense, and you know how to inform your practice. We also offer lots of other useful resources, case summaries, enforcement action. So it's a great place to come and stay up to date, and it doesn't cost you anything. So make sure you look out for that link to join the Privacy Pros Academy on Facebook. And finally, if you do want to network, then make sure you hook up with me on LinkedIn. I'm always posting lots of relevant news. There's great people in my network who you can actually start interacting with, and you can get to know all the people on the podcast and really get to know all the value from everything that we do at Kasian. Now at Kasian, our goal is to make data protection easy peasy. We want to make sure that we protect the reputation of all of our clients so they can keep themselves safe from reputational damage and from enforcement action. But not just that, we want to go beyond achieving compliance and really help them to cultivate trust, inspire confidence, and really stand up for people's rights and show that they actually care about data privacy and ultimately secure more business. The other thing that I do is I teach individuals how to become world-class privacy pros. And as an International Association of the Privacy Professionals official training partner, I deliver the IAPP certifications on a monthly basis. So if you're interested in gaining the global gold standard in privacy certifications to really enhance your privacy career, then feel free to get in touch and I'll be more than happy to help you out. And on that note, I'm going to hand over back to the host. And thank you again, Nathaniel Lamore, for inviting me to this and having me. And Ms. King, thank you very much for reaching out and letting me know about this amazing opportunity to come and share some value.
Okay, thank you, Mr. Hamad, for that wonderful presentation. It was very insightful, and I'm sure our audience enjoyed it, especially your background. It's like you're in Jamaica with us. Okay, so at this time, Mr. Moore and I will be going into the question and answer session. Mr. Moore, are you there?
Yes, I am here.
All right. So our first question is targeted at Ms. Collins and Ms. Marzuko. And it states, are we able to measure and demonstrate compliance with global data and privacy regulations?
Thank you very much for that question. I don't know if Joanna is on the line as well. In terms of Jamaica's compliance with global data protection regulations, is that the question, or specifically?
Yes, Jamaica's compliance.
Okay. Right now, just to draw on what, and thank you so much for all the presentations. I feel like I learned quite a lot. Just to draw on Matthew's presentation regarding the designation of Jamaica. So the GDPR, speaking to the EU GDPR really, the GDPR has certain categories in terms of how you can actually comply with the GDPR as a country outside of the European Union. Jamaica right now is not deemed to be a country that has appropriate safeguards. I think that is about 6 or 7 countries as far as I'm aware. I mean, Jamal and Matt, you can correct me if I'm wrong, but I don't think Jamaica's part of that list. So because of that,
hasn't the adequacy status, which allows the free flow of personal data without any other additional safeguards at the moment.
All right, what did you say? I didn't hear you.
So what I think what you're referring to is the adequacy decision, which says that
exactly
has adequate level of data protection. So Jamaica is not currently on that list for adequacy.
I think it's just like Sweden, Canada, and then there's the privacy shield with the US and the UK. So Jamaica doesn't have that. So what individual
privacy shield has been invalidated now. It's no longer valid. Max Schrems made sure of that, and we can go into
exactly. So in relation to Jamaica, though, individual companies would then have to look at certain appropriate safeguards to see how they would comply. So there's, of course, certification that you could do. You can go to different authorities. The European Data Protection Authority is one. You can look at contractual safeguards. There are certain standard contractual clauses that you can use. So it would then fall on individual companies to look to see how they could individually comply with the GDPR, because Jamaica on a whole doesn't have that adequacy designation. Joanne, I don't know if you want to jump in as well.
No, I think you covered it. What came to mind for me was the list that you referred to as well. And I think that the only thing I'd add is that we want to look at the kind of countries that are on there, and they're all very developed countries. So it's, you know, for Jamaica, it's not necessarily, we're just not there yet. But I think with passing the act and beginning to, you know, implement the Data Protection Act in Jamaica, you know, we're gonna be able to make steps towards being considered, you know, a country that does safeguard personal data in a way that's gonna be acceptable under the GDPR and maybe all over the world. But it's definitely going to take some time and a lot of investment and compliance with Jamaican businesses. So I guess we'll have to see what happens next.
Right. And I'd also like to add as well, as I had stated earlier, one of the reasons why we would have implemented this domestic legislation was really because of that economic partnership agreement that the Caribbean territories would have had with the EU. So it may just be a situation where a coordinated effort across the Caribbean might be something that would help in terms of seeing how CARICOM as a region could possibly be deemed as having an adequate level of safeguards in respect of data protection rights. But as Joanna says, a lot will depend on how individual businesses react.
Thank you for those answers. So this question comes from, let's say I'm a small company and I want to comply with the regulations that are in place, both locally and internationally. And I operate on a small scale. I don't necessarily have a large financial bucket to keep myself together. The question really is, would it be harder for smaller companies to comply with the regulations that have been in place? And a follow-up question to that would be, what advice would you have for a smaller company who is seeking to not cut too much corners in compliance, but be able to comply in the most cost-effective manner? So I direct that question to Mr. Ahmed, as well as Mr. Matthew Sayasi.
Yes, thank you. Thank you very much. And a fantastic question. If you have a small business and you're worried about this, you know, really comprehensive legislation, it can be quite a minefield to get your head around. So my advice to all small businesses is, look, number one is try to understand the spirit of the GDPR or spirit of the Data Protection Act, whichever jurisdiction you're in, and appreciate that you actually want to do the right thing. Which is a great start. You're 50% of the way there. Now, all you have to do is identify what personal data you're collecting, why you're collecting it, be transparent about it, draft a privacy notice, and then find ways of protecting that and keeping it private. And just make sure there's an adequate process in place to be able to justify everything that you're doing to a regulator if they should come knocking on the door. But if you're someone who is running your own business, or if you're someone who has a very small business and you don't have the actual resources or the time to do this, most small businesses I speak to is they're so busy doing so many things, they don't have the time to bring in place, to go and learn about data protection and put things in place. I would say, go and find an expert who can help you to get it right the first time. And when it comes to solutions, don't go for the cheapest option. You get exactly what you pay for. And when you pay for a cheap solution, you pay twice. And I'll be completely honest with you, a lot of the work we're doing in Europe now is repeating and remediating a lot of work that was previously done by some big law firms, sometimes even by some cowboys sometimes. So one of the things we see across the globe, and this is good news if you're looking for a career in data privacy, is there isn't enough privacy professionals. And in many countries, they talk about the data privacy gold rush, right? So people see this as a huge opportunity to go and make money. So if you're going to invest, make sure you hire the right people with the right certifications, and make sure you look for the IAPP certifications, because that is the gold standard, that is the benchmark when it comes to data privacy. So anyone who can demonstrate they've got those IAPP credentials, I would say is a safe bet. Still do your due diligence, but make sure that you cover the basics. You have a good understanding of what data you're collecting, why you're collecting it. Those 7 principles that I spoke about, make sure that you can actually understand those principles and you embed that in everything that you do. And now I'm going to hand it over to Matt to contribute further with all his valuable knowledge.
Yes, yes, we hand over to you, Mr. Saisi.
No problem. That's really good insight, Jamal. I think I'd say 2 things in relation to that. For small businesses, yes, it can be a challenge because let's say like in California, small businesses are generally exempt from the law. It has to be a company making a certain amount of money, or, with the registration provision, if it's a company with a certain number of employees, it's exempt. It has to be, I think, 250 employees in the UK for you to have to register with the ICO. But in Jamaica, it seems to apply to all businesses. So one thing I would say is, one, yes, as Jamal has said, it's important to carry out a data mapping exercise. And that's to understand whether or not this law applies to you, right? So I saw a question in the chat box around, if I'm a cashier and I identify someone, am I using their data? Well, maybe not. So you need to be able to understand, am I processing personal data and does this law apply to me? And then 2, you do have a lot of solutions in the market now as far as regulatory technology goes. So you may not have the budget for it. You may decide to get a solution, something which will allow you to input your data into an Excel spreadsheet, and then it tells you these are your risks, and then maybe it generates for you some privacy notices, and then maybe it keeps you up to date with timelines and acts as what we call as your ROPA, or your record of processing activities, which we find is the primary compliance accountability document for most regulators. So there's a lot of solutions in the market, OneTrust, TrustArc. A lot of these online tools could help a small business at a subscription fee. The same way you pay for your office is the same way now you can pay for some of these regulatory technology tools.
Thank you for that answer. So I can say that the same way a business has to accommodate paying their light bills and paying taxes, they now have to start thinking along the lines of putting in place these mechanisms as something that is essential as we approach the technological revolution. Would that be the case?
So from my point of view, I would say RegTech for small businesses is actually a bad idea. If you have a business that has a number of employees and you can actually dedicate someone to learning that and maintaining that, then by all means go for it. You probably need a business analyst. Otherwise, for a small business, it's actually going to be very complicated. You might not have the time or the resources to train someone to go and learn how to use this tech. And it might be something that actually you're spending money on when you don't have to. You can get an Excel spreadsheet, you can download the template from the ICO, and you can start filling in that information, and it's not going to cost you anything. Now, any regulatory tech, it's like, imagine you've got a tradesman and he's got a set of tools. I can go and buy the tools that a carpenter has, but that doesn't mean I know how to use all of those specialist tools. And unless I go and train myself or train someone to use those tools, there's no point having those tools in my toolbox. So I actually would digress from the advice Matt's given there from the perspective I have of working with small and medium-sized businesses and say, actually, if you're a small or medium-sized businesses, something like TrustArc, something like OneTrust is actually going to be quite unaffordable for you. It might be you take advantage of some of the free tools they have. So for example, if you have a website and you want to manage cookies, they do have very low paid options. But if you are insistent on wanting to get something that's actually appropriate for you, then look at some of the smaller vendors who have actually something quite easy and intuitive to use. And my recommendation for small and medium-sized businesses is you don't actually need a technical solution for this. All you need to do is understand what's happening and put in place appropriate measures, right? No regulation in the world imposes absolute security. No regulation in the world says that you have to have this, impenetrable. You just have to put in place appropriate mitigation against the risks to show that you've done your best to protect it from happening. And it has to be appropriate to the risk. So if you've just got somebody's names, like that's not very private, right? You don't have to go and get, $100 million encryption solution to protect that. But if you've got special category data, something that can be used to discriminate against someone, something that can reveal something quite intimate to them, such as their sexual orientation, for example, then in those situations, you have to put in place stronger technical and organizational measures to keep that information both private and both secure. And sometimes it could be something as simple as making sure that you have a padlock on a filing cabinet, right? That's a technical solution you can put in place to make sure that that's kept private. It might be that you have folders that are restricted to certain people in your organization. So not everyone can see all this unnecessary information that they don't need to see. So there can be really simple and quick wins in protecting that data and keeping it private and being able to demonstrate you're fulfilling all of the 6 principles by demonstrating accountability. All you have to do is say, look, this is the risk I've identified. Once you've done your data mapping exercise, this is the risk. This is what I want to do about it. And this is appropriate because I have a limited budget or because I have limited resources. And as long as you can demonstrate what you've done is appropriate to the risk that we're talking about, then you should be okay from any regulator, right? So the thing that I do as a consultant is I look to or seek ways, pragmatic and practical ways of putting my clients in a strong defensible position, regardless of what jurisdiction they're in, to show that they've taken appropriate measures to justify the processing by making sure that they can demonstrate they've done their best to keep it private and also to keep that protected. Now, the other thing is that there is a difference between the advice I give as a consultant on the practical side and the advice that you would get from somebody like Matt, who is a lawyer, right? So they will tell you they want all the I's dotted and all the T's crossed, but that translating those regulations that was written by lawyers who don't always have day-to-day experience on the operational side, it doesn't always translate 100%. And sometimes there's a lot of lack of understanding of what needs to be done and things don't fit neatly into boxes. No 2 businesses do things exactly the same way. Even if they're in the same industry, even if they're the same similar size of business, every business does things differently. So you have to take those principles and apply them to you in a pragmatic and practical way. And if you're someone who's aspiring to be a great privacy professional and you want to get paid really well and you want your reputation to precede you, what you want to do is be a business enabler. Businesses have objectives. It's your job to balance the business's objectives against the requirements of the law, keeping people's information private, protecting it from the business side, doing all of that in the most pragmatic way possible to keep things easy and fluid and enable the business to meet their objectives, provided they're doing so with an ethical framework in mind.
Great, thank you, gentlemen. Oh, go ahead, Nathaniel.
No, I was just going to thank them for their answers. I like how both of them went into detail and provided different solutions for the small businesses. So I hand over back to you, Shamon.
All right, so our next question is in relation to tourism. So in Jamaica, tourism is a major player to the economy. And this is in relation to social media marketing. So a lot of hotels here in Jamaica utilize emails, locations, numbers, information of that sort to attract tourists to the country. So what advice would you, any member of the panel, give to persons who are in the tourism industry to be compliant with the GDPR? It's a loaded question, I know.
Yeah, so I'll start off with this one. It's something that keeps me busy on a daily basis. So look, when it comes to marketing, it's probably one of the most significant things for a business to stop doing because of GDPR. And what we saw in the UK and in Europe when the GDPR first came in 2018 is, for some reason, there was a lot of bad cowboy consultants going out there telling people GDPR is all about consent. All these people had a marketing database. They said, you know what you need to do? You need to go and send an email to everyone on your database, ask them for consent. People were getting hundreds of emails from all the companies out there asking them to consent. And what did most people do? They just ignored them. So most businesses lost 90% of their marketing database because they took bad advice. So the first thing is, don't do that. Don't go and ask everyone for consent. Identify what legal basis you need for the kind of marketing. And depending on the jurisdiction you're in, you could rely on soft opt-in, or you have to go get consent. Now, if you have to go and get consent, make sure that you get that in a way that is appropriate. And Justine and Joanna did a great job in explaining what is valid consent according to the Data Protection Act, and it similarly matches what we see as the gold standard in the GDPR. So remember, consent is not the only thing on the only way to market to individuals. You can have other lawful basis where you can market to them. So make sure that you actually do your homework. And the best thing to do to answer this question in a way where it's actually appropriate for you, because remember, what's appropriate for you is not going to be appropriate for the business next door. It's all relative, and it's what's right for you. Go and get an expert, go and hire a consultant, go and get somebody who can actually help you, because then you will see that return on investment. And actually you can use this as a competitive advantage. I mentioned earlier, Amazon, Google, Apple, all of these companies are telling you about how much they value their privacy. Get someone to get it right for you, and then tell people how much you value their privacy, and you will see that 63% of those people are more likely to do business with you than someone who is competing in the same space as you, but that doesn't offer or doesn't talk about how important privacy is to them and their business, and how much they value the privacy of their customers. Especially if you're targeting tourists in the UK, if you're targeting tourists in the European Union. There's 500 million people in the European Union. There's 70 million people in the UK. And these are people who actually want to come on an island to Jamaica to spend lots of money, but they are very aware of their privacy. They care about their privacy. So tell them how much you care about their privacy, and you'll see how much more business that gets you.
Okay, thank you for that, Mr. Hammond. Okay, so the next question is in relation to, well, to rephrase, what would you describe as an adequate level of protection for transfer of data outside of Jamaica?
So any appropriate safeguard that is legally valid is an appropriate safeguard. So you just have to make sure that you pick one that is relevant to you, the one that is the most pragmatic and practical for you and your organization. And that is the best way to go forward. There is no blanket answer to this. It really depends on a case-by-case basis. What's right for you is not going to be right for somebody else. If you're a multinational organization, you might say we want to bring in binding corporate rules. If you are not a multinational organization, you might want to say we're going to rely on standard contractual clauses. You might rely on an appropriate certified mechanism, depending on the industry you're in. So there is no answer. The answer to the question is identify what is the most pragmatic, the most cost-efficient solution for you, and what makes most business sense for you. You can find out what all of the appropriate safeguards are, explore them, and then use the one that is most appropriate for you.
Thank you for that answer, and thank you for your engagement so far during the presentations. For this question, I'm going to ask Joanna to answer this question, as well as Ms. Collins. I am asking this question from the perspective of a person who is starting a law firm, or a person who already has a law firm. And as we might know, we're moving away from strictly having our client data stored on paper. We're moving towards having data stored on Dropbox and on other legal databases. The question that I have is, what are the things that we have to take into consideration while trying to save client information on Dropbox and these other legal databases? And another question that would come from this is, do we have to take into consideration that the information is actually being saved elsewhere in another country if we use a legal database that was probably created in the US?
That is a good question, Nathaniel. But I think before we even get to data protection on that, if you're starting a law firm or you're already in a law firm, you need to first be guided by the rules, the Legal Professional Act, so in terms of our obligations with confidentiality and so on. So that needs to be, at least for the time being, and moving forward with data protection, that needs to be a very strong guide. Following that, under the Data Protection Act, there are some of the legal basis for collecting data. One of them would be to fulfill a legal obligation. So attorneys have KYC requirements and anti-money laundering requirements, which include retaining the data, KYC data for a particular amount of time. So those are things you need to keep in mind with the type of data that you are storing. So as attorneys, you can be storing some very not necessarily sensitive data under the Act, but very special, for lack of a better word, data, account information, particulars about clients. In some instances, you could be processing sensitive data in litigation matters that have to do with health data, things like that. So you need to ensure that whatever processing, whatever safeguards you have to protect that data are appropriate. So if something like Dropbox or whatever method that you're using is not appropriate for the particular data that you are storing or processing, whatever the case is, you could be found to have breached the Act, particularly if there is something like a data breach or a security, whatever it might be. That's going to really depend on a case-by-case basis, I think. But generally with attorneys, you're going to need to have a strong safeguard because of the type of data that you could potentially be processing.
Yeah, thank you so much, Joanna, for that. Just to support what Joanna is saying. So generally speaking, you have your ethical obligations of confidentiality, which are distinct from data protection obligations, because data protection obligations are conferred by statute. So confidentiality, notwithstanding that, you still have, notwithstanding your data protection obligations, there is that carve out that still subsists whether or not we're in the digital realm or we're doing physical papers, or it's not even data protection related. In relation to the Data Protection Act specifically, apart from the lawful basis of processing data that Joanna would have mentioned, there's also there are some exemptions under the Act which allow for persons, if they're receiving legal advice, legal professional privilege, there are some exemptions and carve-outs in the Act for that. So there are exemptions in respect of certain standards that you would need to comply with. Can't recall right off the top of my head, but I think it's the first standard. But so there's that. But then there's also, as we spoke about the ethical aspect, there's also a school of thought, and I think that Chris would have mentioned it earlier, and I thought was really interesting when he talked about that concept in the US of selling data subjects data, which to me kind of sounds similar to data subjects owning data sort of like a property right. We do have some rules that speak to protection of client property. It's not very specific regarding whether or not personal data could be deemed to be property, but there is that scope there. So generally speaking, aside from your confidentiality, you do, as an attorney, have an obligation to protect client property, which could be argued to include personal data. Cloud computing, Dropbox, all of those things, they do have privacy policies that are well, they should, right? They should have privacy policies in terms of their terms of use. Any kind of technology that you're using as an attorney, you need to ensure that you read your privacy policies. You're familiar with what information you're storing, how you're using client data. You definitely need to keep apprised of it. So if it's a situation where there's a breach, you will have to account to the Information Commissioner's Office, and of course the client. So I think just as a practical point of view, just make sure you're constantly aware of what products you're using, the privacy policies, the implications of them, the history, the reputation. You don't want to be like saving it somewhere where, you know, just last week and the week before and every single week there's a breach and you're just like, why am I using this technology? So yeah, so I think that's my response.
And just a follow-up question. I speak from the perspective of someone that's saying, okay, I've heard all of the presenters talk today, and honestly, I do think, you know, data protection and is important and complying must be important. But I feel like I can get away with not really fulfilling all of the criteria. I feel like I can get away without being mindful of the 8 standards that are there. I feel like I can push my way through. What are the type of penalties one can expect from not complying? And I asked you that question, Ms. Collins, and if there's anything else that you'd want to add, Ms. Marzuka, we could ask you as well.
Well, Joanna would have gone through a lot of the penalties in the Data Protection Act, but there is a general penalty clause of 4% of the annual gross worldwide turnover. So that is in terms of just like breach of the act generally. There are specific offenses, about 6 or 7 of them, which carry specific penalties for them. It'd be kind of hard to reproduce them right now, but I yield to Joanna because she would have really gone through it in her presentation.
Yeah, I know. I think Justine covered it. I think the only thing I'd add is that, you know, while the penalties are, of course, very important, like I said in the presentation, you don't just want to limit yourself to what's in the act. You also want to consider the reputational risk of a data breach or poor data protection generally. We had talked earlier about, for now at least, individual businesses are going to have to take control of the type of data protection that they offer in terms of if they're going to be considered a recipient of data outside of Jamaica. You know, that may affect a business deal at some point if you don't have adequate data protection. And then you also want to think about how any of those reputational, that reputational risk is going to eventually affect your bottom line. So while the penalties are important, they're not the only financial consequence.
Thank you. I have no more questions. I hand over to you, Shamon.
Okay, so I have a very interesting question that was asked in the YouTube chat, and I guess all members of the panel can answer it. Well, specifically, the first question is, what is it like working for one of the top law firms in Jamaica? This is directed at Joanna and Justine. And then I guess Mr. Saizi and Mr. Hamad can briefly describe to us what it's like working in the UK as privacy professionals.
I think that Matthew and Jamal and Chris are off the call now. I think it's just us on the panel, which probably is an indication. But what's it like? I mean, I work for a very small firm. I think my house, Fletcher and Gordon, is one of the largest firms in Jamaica. Well, we consider ourselves to be small. I'm not sure if we're small anymore. But I think that it's exciting. There's a lot of new things each day, and in specifically commercial law practice, which is what I wanted to do. There are different types of transactions, and it's interesting to work with different clients at different times, and multinationals and international clients. I enjoy that exposure and meeting new people. I really enjoy not going to court as well, so I try not to go there. So I would say that I enjoy my days. Joanna?
Yeah, I would agree. I've had the same experience working at a firm like HMF and MFG. It's definitely well, I don't work at HMF, I work at MFG. But you know, working at a larger firm is definitely a great experience. The exposure is much more than a smaller firm. Types of matters, the diversity, it's great. It's really exciting, like Justine said. I would recommend it for sure, particularly for younger lawyers, because that's the stage that you are really supposed to be soaking in as much information as possible. So that would be my advice.
Okay, thank you for that, ladies. Well, Mr. Hadak, Mr. Hamad, and Mr. Saizi had indicated that they would have to leave. You know, Mr. Hamad and Mr. Saizi, they are both in the UK, and right now it's probably 1 a.m. I'm not sure, 1 a.m. or 12 there. Which is understandable. So at this time, I'd like to thank all our presenters for taking time out of your busy schedules to come and share with us this wealth of information. And I will hand over to Mr. Sanjay Roden, who is going to give the vote of thanks.
Shamon, I know that some persons are having some technical difficulties. So in the interim, I must say thank you to the Foreign Affairs Committee for being very dedicated and determined to have this forum, have this symposium put on. I must firstly specifically thank you, Shamon King. You have definitely been very instrumental in having this event come to where it is right now. We have one more day left, and I must say, you are probably one of the most hardworking persons I've ever gotten the opportunity to work with. I must thank G2K for coming out, the members of G2K for coming out. We see you guys in the chat, we see you guys in the groups, and we really do appreciate your support. We must thank the members of Hewing Law School who came out, the members of Eugene Peuse Law School that came out, and especially the Norman Manley Law School family for attending the event. We must also thank the persons from Mona Law Society, persons from UTEC who came out, as well as the members of the legal fraternity who are present with us still. This has definitely been a truly informative session. I personally got the opportunity to learn a lot from this. I had a personal love for this because I had gotten the opportunity to initially go through the Data Protections Act, and trust me, it's a beautiful legislation when you really get to get into the nitty-gritty of it, and it's something that it's very interesting. As young persons, we have to adapt with the times, and we do not want to get left behind. We really have to put ourselves on solid ground so that we don't end up like the persons who are walking on the crates. We have to be secure in what we're doing, and we have to be informed with how we approach things. I must thank the speakers. Most of the speakers are not still with us, but I must thank the speakers for coming out. Your input has been appreciated. I must thank the persons who have attended from across the globe. Persons, it's basically midnight now in the UK, and they got the chance to come out and they shared their information. A lot of them decided that had confirmed last minute, and they came in and they did what they had to do. And there's really no communication barrier, no barrier in any shape or form. I've been seeing the feedback, and everybody has been appreciative of what has been going on. So with that, I must say, everyone, if you're impressed with what happened today and you want to learn more about data protection and cybersecurity, and you've heard a lot of mention of the GDPR, the parent of the cybersecurity, the data protection legislation that we have here, I would encourage you all to come out Friday, because we have another one of these sessions, the final day of the symposium. On this final day, we'll be announcing the winners for the giveaways that we've been having so far, and we will have some special guests that you might not see on the flyers, but trust me, there's a treat that is waiting for you all. And with that, I must say thank you for coming out, and be blessed, everyone. And also, as I said at the end of the last one, at the end of the last session, you would not want to leave your Facebook account without a password because you want some form of protection, which is why you all should get vaccinated so that your bodies can be protected. Thank you all for coming out today, and be blessed.